We're live.
The Senate Education Committee, February 18th. We start the afternoon by spending a little bit of time. We kind of walk through, ask questions, mark up whatever of S227. Having to do with education, safety, and immigration. You don't have anything for us specifically.
No, but I've been watching the testimony and I can answer questions and provide some guidance.
I think we've all made a lot of notes, and so yeah, we haven't had you back in. So
Yeah.
So we're here. We heard from the Superintendents Association. We're going to hear from the School Boards Association. But I've got a bunch of notes that we can start with. People can jump in as we go. I have a note here on the side that you may have heard this testimony, but to the effect that we need to have broad language to show that the privacy of data confidentiality goes to more than just ICE to make sure that it's applies to more law enforcement.
Does this have kind of what I would call like data minimization? The best practice would be to not collect more information right now than is federally required, or even
We didn't get into the information for schools, and this is more about just keeping whatever it is they do confidential.
So on page 3, that's if you want to look at that.
I'm seeing it now. Yeah, exactly. Right. Like I'll just say out loud, it was helpful for me to learn it's not good to write down someone's country of origin. They don't have to do that. They could just say from the US, not from the US. And that's helpful right now.
So that would be a policy change that we'd be making.
Well, no, it's just a best practice because nothing in state or federal law requires.
No, I understand that.
Yeah.
But some may do it. I'm going to take that. So what do we have? What would the bill be this month?
So on page 3, subsection E, student records. School districts are prohibited from using policies or procedures to engage in practices that have the effect of excluding a pupil from school. And then here's the important stuff: collecting or requesting information regarding citizenship or immigration status of a student, of students, or their family members, except as required by state or federal law, or if required to administer a state or federally supported educational program. And then 2, this designation of immigration status, citizenship, place of birth.
Place of birth.
Yeah. So, and you heard testimony about the 2 federal laws that prohibit state from prohibiting the sharing of information, and the 2 key categories is that immigration status and citizenship. So what the federal law says, and I think Julio Thompson talked about this, is that a state can't prohibit that sharing with the federal government, but there's nothing saying the state cannot collect that information. So if you prevent the school from collecting it, then they can't share it, right?
Yeah.
So that's the maybe end around if you want to discuss ways to do that. There's other issues that I want to get to with that, but that's if you want to talk about privacy first.
Let's stay on that for a second, because I think Senator Ron used the point. It's well taken that we can.
Yeah.
If there's no real reason to do it, let's do it.
Which I agree with that, but why is it, the other question, why is that such a big deal that you do know the origin of the country they come from? You just feel you use that against them? Is that what you think the law is going to use that against
Not
them?
trying to be too political. There has been targeting of people based on specific nationality and specific regions of the world.
So what you're going to say that they don't even come to the school, they call and say, we want this information so they can know the information, extract the information to say, okay, now I know Keisha Hinsdale is from some other country than here. Now we're going to check it out.
Yeah, I mean, let's just say I'm all about data collection under normal circumstances, but right now, if we are being asked to turn over sensitive data that states have not been asked to turn over to the federal government before, probably collecting less data is reducing harm to those who the data is about.
So what about in the future when you may want that data? Are you gonna want to come back and change this, or?
I would love to see that future in my heart and mind. But you know, it probably is going to remain a best practice for a while to not over collect information. There's really no material reason they need it. They might have just wanted to do some.
So I just want to be clear, the only reason you don't want to collect it is so that if they call for that information, not come to the school, but call and say, hey, I want this data, that the less data, the better, so it doesn't.
So I don't want to, like, I want to use a real world example, but not with the intention to malign any community. Even if they know, oh, this school has a lot of Somali American students, that's probably not good for that school. So it doesn't even have to be identifying information of a particular student for it to be of concern right now that we not release too much information about the demographics of a school.
Not even take it in.
Not take it in, not have it on file.
I don't mind that. Just that later, like you said, when you're data driven,
Mhm.
well, when you go into the doctor's office and they ask you all
Right.
kinds of stuff, it's like they're going to share that with somebody. So that's what you're worried about. In this case, going the wrong way, but normally it's like we want all that information, but now we don't. So just clearing it up. I'm happy with it. Thanks.
So I have a note here, I think this is covered, but federal authorities have no right to enter public zones without a warrant.
I want to talk about that. So if I can, last time there was a question about S209, the bill that limits civil arrest in sensitive spaces, including schools. And that's a pretty broad definition of what a school is. So that bill passed the Senate. It's now in the House. I think it's important to think about that intersection with this. So just to kind of summarize S209, the way it currently is, which it may change in the House, it would prevent the civil arrest of a person, and for this committee's purposes, at a school, right? This bill would not necessarily conflict with that. However, this bill requires a judicial warrant that the superintendent or designee get a warrant before that, and this is specific to federal law enforcement, which I think maybe you want to change that. Any law enforcement comes to the school, in order to get to a non-public area, they need to show a judicial warrant. And I think we just need to think about how that intersects with 209, if it passes or not, and how you want to maybe work in that language a little bit to make it what you want.
Well, so the thinking was that it would be more likely to stand up scrutiny if the including wasn't just isolating one branch of law enforcement. And so I think we'd like to go in that direction. The challenge is what, I guess we could say unless invited, because it's not uncommon for a local law enforcement officer to get invited to the school. And for totally benign purposes.
And then the school resource officer, I don't know, if you want to think, because they are law enforcement, right, technically. So I'm not sure how you want to consider that, if they are invited on an ongoing basis, or
if they're a school resource officer, you can't just exclude them, right, from this.
you can't. That kind of lends itself to, you want to, as I think, right?
I get where you're
Okay, all right.
Okay.
The more you kind of pick at it and target it towards something, but I think school resource makes, if you want to exclude that specifically, that does make some sense, because they are literally part of the school ongoing practices, procedures. So I can think about that too, but
Yes. So
Yeah, so thinking of an entirely different scenario where we do want law enforcement on site without a warrant, if there's like an active shooter or something like that, I want to make sure we're not creating a dilemma an administrative dilemma for the administrators at the school.
That's a felony. This is
This is,
civic.
but it says judicial
That was
warrant,
209.
you know, I
Now you're in my head now.
Yeah.
mean, one case we're trying to prevent, the other case we're trying, we need,
Yeah.
you know, expeditious entry, so. The other hesitation I have is that, if I were a principal, actually, me personally, as an individual, I would know a judicial warrant from another type of warrant from, I would have no idea. And I'm curious how the principals are going to be making this decision. And actually, it says here superintendent, so, you know, here you have a superintendent may have 20 schools, you know, is it really a superintendent or is it the principal or?
Designees.
Well, one of them says designee and one of them doesn't.
Where doesn't it?
Page 4, line 4.
So, subdivision B, 1B, that they would designate at least one individual to serve at each school site.
Oh, there, you go. So it's okay.
Um,
Different purpose, or same purpose, different.
So I think the guide that is in section 2, the immigration resource guide, would be something we can beef up and have the AG provide language to superintendents that say this is what the warrant looks like. This is a administrative warrant. This is a judicial warrant. I think that's a good thing to think about is this is a lot to put on the employees of the school. So you want to be as helpful as you can, saying that this is what we want you to do. These are how these things look.
So before you go on, Julio, why don't you identify yourself for the record?
Oh, sure. Good afternoon. I'm Julio Thompson, Assistant Attorney General, Co-Director of the Civil Rights Unit. Thank you for inviting me.
Just so that we call on you for questions as we go, you will have been introduced.
Fair enough. Sure. Thank you.
And by the way, if you are listening, if you go like that, that's fine. Do that. I'll recognize you. Because if you got something you want to jump in on, do it now. It's okay to do it.
Well, I had
Okay.
maybe 2 minutes ago. But
Okay.
Maybe I can pick it up later.
Okay. All right.
You know that? Yeah.
But thank you for that.
Yeah.
invitation.
So we're looking at subsection F around on page 4. So I guess, yeah, I think we need to think about. I agree that we should not confine it to federal immigration authorities. But it's correct that there's not really an exigency here, that if law enforcement comes because they're shot fired or they hear something, they don't have a warrant,
Yeah.
but they hear shots fired or they get a phone call. You know, I think maybe you want to think about that too, and how you want to word that, or not word it, but how you want to structure it.
Do you have enough of a sense to try something on for us?
Is that kind of where the committee wants to?
I don't know if it's the exact same place, but there's a lot of adjacent recommendations to tighten the language around.
Well, I've got something to say.
This is from Rebecca Callahan, who's been looking at what other states are doing to tighten up who's considered a school employee, what's considered school property, et cetera.
Yeah, I've got that.
Okay, I forwarded it to Rick and Julio. Can I print it for people? Because this might answer some people's questions about
Received it.
how the language might be tightened, or maybe more specific.
Did you just send them?
Well, as long as they have it.
I don't know, because
I haven't seen it before.
yeah, she definitely didn't email Rick this. She emailed it just to me and she said, this is more comprehensive than what I shared with Daphne. So I'll just send it to the committee.
Okay, that's
Okay.
fine. Yeah.
Might be something for the amendment draft. You know, I can.
Yeah.
And I forwarded it to
Yeah.
you already.
Yeah.
So it's on page 2. That's good. I have a note next to 2
Yes.
saying athletic events, open house, school plays.
Yes.
How do we and like a football field, they don't have the right, have a football game, is that?
I think that's it. I mean, what she did was scrape from other states. So it might be good to just try not to reinvent the wheel.
Well, Rick will have it, right?
Yeah, he has it. Everybody has it now.
Okay,
Yeah. I haven't had to look at it, but, so, Mr. Chair, you're right. This is, in my opinion, football field. I'm not sure, because you do have a few examples, classrooms, cafeteria, gymnasium, playgrounds, and any other location where students gather. That's a little squishy at the end. I think if you want to exclude athletics, you should be specific. If you don't, if you remove the specifics, I think it becomes just a place where you have to get through some kind of authority to get into the school, get into the classroom, right? So I think,
I think kids ought to be left alone, and like, at the football game, it's the same thing.
Yeah.
So I would include with that.
Thank you.
I do agree with Rick, though, that the last part of that sentence is too mushy. Any other location where students gather, the follows, you know.
There's location spelled out in for Phil.
That could be a Friday night.
I mean, it's-
Feeling.
it would still be part of the school, Senator. It would still be, but understood that doesn't really make it easier to understand. Because you want law enforcement to be able to understand this, and you got, and superintendents, and they have to be able to see, okay, this is where a warrant required. You know, we can't put them into the gym or into the cafeteria because the law says, you know. So I think a list makes sense.
So if they're after said individual and they run into a school, are they gonna be protected under this? Or if they,
Yeah.
if they are came off of the public grounds and into the school and like just seconds, the door closes, is all of a sudden this apply?
So as written, it applies to federal immigration authorities, and that would not be a normal occurrence, I don't think.
No, I
But if
don't.
we're changing to all law enforcement, this becomes a bigger problem.
Mhm.
Because now you have an exigent circumstance, there's a chase, or like I said, shooting, something has happened. And there's probable cause to go into the school before there's suspicion that something's going on in the school. So it needs to be rewritten, that portion, and we need to think about how to, you know.
I'm concerned about that because if it, it could be a teenager that's committed a,
No, I understand.
Yeah.
yeah, and might be border patrol chasing them or what happened up at the border that worries me. In the school, around school. But if they're actually trying to apprehend somebody that's done a crime,
Well, remember when we're talking about immigration protocols, it's a civil matter. The second it's a criminal matter, it's not an immigration related detention. It's a criminal matter.
But if the bill's being expanded,
Okay,
if we're.
that's what we said in
Yeah.
S 209. I thought so.
S-209 is a civil arrest, so if it's,
Mm-hmm.
that I could live because it's civil, not
Right.
a felony or misdemeanor.
the intent of this bill is to protect kids, right,
Yes.
from
Yes.
various interactions.
This is
With
essentially
police.
saying they have to have a judicial warrant before entering a non.
Which you don't always have, right? If it's exigent
Yeah.
circumstance, you don't have a warrant, you don't go to school.
When we start doing exigent circumstance, everything's gonna, that's gonna swallow the roof.
Mhm. But it isn't for all law enforcement.
No, it's, but being it was immigration after this said individual.
I think CPP is considered traffic. But
They're part of they are defined as a federal immigration, because they're under DHS,
excluding,
ICE and CBP are both under DHS.
Because we have schools very close to the border.
right,
Well, yeah. So exigent circumstances would
right.
always control, right?
Not to your house. That's Julio's probably a couple Fourth Amendment cases where police can go into your house, but it's very, without a warrant, it's very, very rare.
Well, I
So-
mean, in this situation,
Going into a school,
yeah. Then we get into the whole
you
discussion.
know, a 911 call from someone inside the school saying that there's shots fired, or something's going on. There's a fight, right, that we need to break up. They're not gonna be a warrant for that. Police come out and they come in and there's a situation. If you expand the bill to include all law enforcement, they would need a warrant, and that's not gonna work. So once we change this to be all law enforcement, we're gonna have to rethink about how, I think it can be done. It's just not, this language is not gonna work.
And this, I mean, well, this says, I don't know, this says in the event a federal immigration authority enters a non-public area of a school site without approval, the school shall not obstruct the federal immigration authority. So it can get sorted out later, but I think, you know, they can
All
use
protecting
discretion.
our students and our children. Um, but I don't want to impede if it's an actual crime. And they
Then I-
know that they can run to the school for protection because they're well read. And they know, hey, once I enter that school, now he needs a warrant.
Well, the
If they-
school wouldn't obstruct anyone in law enforcement, I would think, from getting a dangerous situation under control.
But you understand, the act out on the street, if something
Mhm.
happens, they're trying to apprehend it before the individual gets to school. I'm talking, you know, I'm 15 and above. You know, 9 through 12 is what I'm worried. The younger kids, I don't ever see it, but they try to apprehend outside on because he is a convicted, one, illegal alien, two, he's been coming to school, or however you like to put it, undocumented
Mhm.
an individual.
Yeah.
They have the right, you know, they have him in a pickup list because he has, or she, they have committed a crime and they run into the school just ahead, the door, the other students coming in, door closes and locks. Now, do they have to get a warrant or can they pursue in and say, we are trying to apprehend this individual because he has committed, she may have committed a felony.
Okay, well, crime is
It's
different than
very
felony.
rare that this would
Yeah,
ever
yeah.
happen.
Right.
Could get a warrant.
That's right, but you know,
If it was the kind of criminal matter that happened in the state without a border involved, CBP or ICE would not be the ones going to apprehend.
I would normally say, yeah, because down in Burlington, but Swanton, Irving, Cannon, that's a possibility.
So a federal immigration authority would rarely have a criminal investigation
Right.
or a student at school. That's a pretty, I think, a pretty extreme. It could happen.
Again, it's extreme, but
Yeah.
we, as policymakers, we're supposed to think of the full spectrum and knee-jerk reaction, this is good, let's go with it. Then an incident like this happens and it's like, why didn't you think this further through? And that's all I'm asking us to do is speak. Because I like this bill, but I don't want to protect somebody that knows how to use this to their advantage. Which I doubt it'll ever happen. I doubt it'll ever happen, but
I mean, we are seeing more of a likelihood that kids get traumatized by immigration officials coming close to their campus or, you know, threatening to come to their campus than we are this situation. So I think it's really a balance. And I do think
I just.
people
voice
have
my concern.
discretion. People have discretion.
And if we can write something in that.
This
kind
is
of
the
help that.
policy best practice.
So non-public area, just to put a, and on you said me like, the language on the non-public area, and we'll have conversations about how to structure that. What that means.
We have on page 3. Line 5, that we don't have this stuff the first day. Questions about the word partner. Line 5. And then the question is, what is a group of advocacy?
Yeah, no, not fine. I remember I had in my notes, Major Senator Long still the immigration advocacy institution was suggested. Liaise as a partner. Keep in mind, it's to the greatest extent possible. So this is not required. It's suggested, highly suggested that they partner or come to some kind of terms with some kind of group that, and you can see the purpose, provide assistance to a student that has had their guardian detained by immigration. So I don't know how common these places are in Northeast Kingdom. I don't know how common they are outside of Burlington. So do you partner with somebody that is nearby? Do you partner with somebody that's in Chittenden County because they have the authority, the space, the employees to help you? I don't know. I'll be curious what the superintendents think about this. I don't know if they gave specific feedback yet or not, but
they raised a bunch of issues. That's the middle suggestion language as
Okay.
well. So, yeah. So what had you just said instead of the go out to?
so in immigration advocacy institution instead of legal,
Yeah.
something that's specific. I think it was your suggestion.
No, it was not, or
Otter.
he wanted to say legal
Yeah.
and immigration, or at least
That's right.
immigration.
That's right. It's not-
Yeah,
Yeah, but you're right. There are organizations in Vermont that are here to help with immigrants. They may not be, but they also might be a good partner because they have the protocol. I don't know, they've had access to, they have their own access to.
Right.
I actually like the word partner, by the way, because it suggests forming a relationship.
right. I mean,
Way it's not even what that means. I know what it means, but
Yeah.
in this context, I'd rather say that it's a good idea to get yourself hooked up with somebody who's going to help.
Right.
Time comes.
right. My daughter wrote the standby guardianship legislation, or at least kept out of Senate Judiciary. But at the same time, there are attorneys who are able to help with standby guardianship regardless of immigration. I mean, you may not have but I guess I'm hitting the chair because I don't know if, based on his testimony, he feels like to do immigration related standby guardianship, you need to do something different than other standby guardianship, like if someone's incarcerated or going on an extended journey.
Or if they haven't done it ahead of time.
Right.
Sorry. Oh, yes, yeah.
I just suggest a resource to the committee for further information. So two legal advocacy organizations in Vermont that I know do this sort of work if a parent is detained, because you can have mixed status households where kids are citizens or lawful permanent residents. Would be, I think, to get input either in written testimony or for video or even in-person testimony from the Vermont Asylum Assistance Project.
Yeah.
Which handles these sorts of issues on a daily or at a minimum weekly basis, and the Vermont Law School Immigration Clinic. I think they would have a better sense of how to phrase the people who are best suited to provide that security and stability for children at that very uncertain time. And I think, I think it would be, they could probably get you to the answer quicker than I think our office certainly.
What's the program at the law school?
I think it's, I'm not sure the current
Immigration
name is for that. Yeah, it's Vermont Immigration Law. But I think
Okay, immigration, okay.
I mean, which was previously run by two attorneys who are now at the Vermont Asylum Assistance Project, so they could probably say what the clinic could do.
I consider them to be the subject matter experts.
They are, yeah.
in Vermont.
Aaron Jacobson and Jill Mark Diaz are the subject matter experts.
Can you just be in touch with them?
Yeah.
Yeah.
And see if they want to be
Or no, just see if they have thought for you about how
about
to
a specific.
Yeah.
Okay.
rather than us have to take the test.
It's the law school or this?
Do you want me to, I'll just
I know,
email
I
Aaron
think-
Jacobson and Jill Mark Diaz and copy you all.
Yeah, do that.
Be easier to reach them.
Yeah,
I'm contacting them regularly.
give them a link, give them a link. We come together.
Oh,
okay.
I have Aaron Jacobson's
Okay.
Berlin email, but you now is that back?
She left, yeah, she
Yeah,
left
yeah.
that.
Um, So to the extent that we talked at the beginning about making sure that the ward was was for all. I have a note here on page 3 also saying, make sure that the immigration status is kept from all, including state rules, etc. So I don't know if it's not just the warrantless entry, it's also that status of confidentiality of last of all, they covered that in those instances.
Are we still on D or are we on?
Oh, I'm sorry, that's moving around. Yeah.
Because D does
No.
the immigration with, I think you want to keep that correct. The guardian, we're talking about, in D, the guardian detainment. I think it's, you're probably safe to be specific to immigration because you're not. Targeting federal.
Okay.
Yeah,
Yeah, I had that note for generally. What the-
it is more generally.
Okay, okay, just, and then I asked. A note about whether the policy should have to, that's developed by superintendent should be reviewed every couple of years.
Oh, this is the very beginning. This is the on page 2. Policy required. Each school district and approving infant school shall document a policy. Each superintendent and head of school shall develop input procedures. Yeah, we can add language there that says shall review and update if necessary every 1 year. Is that what you want to, every 2 years?
Yes,
Do you think that is something that, education, yeah, I'm blank here, our education department could write it up so that it goes, that it's they have something that they can work on, that they just, hey, we need this document and get it, rather than relying on each, or do you think schools need their, so to kind of craft it to their own school?
well, I think you're talking about perhaps the model policy.
Yeah.
And I forgot what we landed on that, because I can ask on what.
Paul, it's a good thing to think about. Policy wise, it's up to you. Would it be easier to have AOE or wherever you want to charge with it? It's only the most important
Yeah.
thing
Yeah.
answer. If you want to charge AOE with that task or the AG's office or in coordination, the guide, on page 5, the
Yeah.
guide is the AG in coordination with, AG in coordination with, with AOE. So some form of those two developing this, because there is some, I think you want the AG to at least be consulted.
And that way we don't put the pressures on the school.
Oh, no, I think a model policy, they can do what they want with it. But give them a model policy.
Okay. You think AOE and consult with the AG would be a good way to work that?
Well, yeah, that's a good question, which way, yeah, that's probably right, AOE and consultation, yeah, you do.
These days will need to be moved anyway, the guide, it's March 2026, so that's a few weeks. Where's this immigration guide? It's not long, this is required. So I think you're gonna have two, things were charged. The AG is gonna make the guide, AOE is gonna make the model policy. I think you need to think about dates. I can put in some placeholder dates, but think about when you want those to be.
Should that be a call to them to say, hey, I want to be pick up tape, so we can say the day the law is enacted, it gives them 2 months or something?
Maybe what you could do in the next draft is just leave a blank.
Okay.
And we'll see, and then there was also I have a note, on page 5, again, saying about timeline, August, maybe that's what you're referring to. August 1st is also very aggressive.
Yes, it is.
So. Well, I'm just make that a blank.
I wrote this in 2025, and I of course,
Okay.
that's years away, and it's the next month is 2026. So I think that's maybe what happened. But yeah, obviously, you can update these and all these. So it doesn't.
Okay. And so last time you did it, about a year,
Or
to get the guide ready for the policy adoption.
which bill we are speaking.
Well, you said you wrote this first.
Oh. Just because it was December or November when I wrote this, and 2025, I'm thinking of 2026 is a long time away.
So you wrote this, let's just say November, December, and so you gave 7, 8 months.
Right.
for it to happen, so.
And I'm sure there's ones they can plagiarize.
And this was also coming back to me, that one of the reasons we made it so aggressive was because of the school year. But that may not, may not, let's think, I don't know.
Some of the things you can have multiple templates. The student records piece, where you prevent the taking of the student records, that can be done quicker.
Yep.
And the, appearing on site, the regulations there, that can be done later, once you have AOE, AG guidance. So again, the dates can be adjusted.
Okay,
The dates of updating it or
no, on
implementation?
page 5, the implementation.
I think we should be pushing for as soon as possible and then
That's why
hearing
we did it.
pushback.
That's why we did it.
But the good news is AOE had a lot of this written down. They just didn't call it required policy. It was the guidance. So I don't think it would take that long.
So we know March won't work.
Why don't we check with
Well, who's them?
the AOE?
For the
say-
school boards association.
Yeah, or the guy.
Yeah.
Yeah,
Well, can we leave that blanket for now? Leave in August 1st
Yeah,
as your suggestion.
I think they're going to do it
We'll see
either
it.
way
Yeah.
and they
Uh,
need.
I have in my notes that AOE needs a year. I have that in my notes. AOE needs a year. I'm not sure if that was Emily Simmons who testified that or, but I'll leave it in for now and then they can give you a specific.
Yeah, okay. Push much more. Anybody have anything else? Limits? Yeah.
Sorry, I have one. The Office of the Refugee Settlement. I think Julio may have talked about that. I've heard it several times.
I think what was suggested was that, which I don't think is a good idea, by the way.
Okay.
But that we substitute the resource guide, have it say the Office of Attorney General in consultation with the Office of Refugee Settlement, rather than AOE. And I don't think that's a good idea. We could add them as a third.
Okay.
In consultation with the agency and the Office of Refugee Settlement. That probably makes sense.
Those are my notes from watching the census.
You have it there?
Yes.
Okay.
Check, okay, switch.
Yep, might as well. I'll stay here.
Tucker, are you on a time crunch?
I will have to leave at 3:00.
State again, Julio Thompson, Attorney General's Office, Civil Rights. Before back into the 50. Some of these are minor suggestions, but I think it makes a stronger bill in terms of accountability, following the policies. There are a few provisions in S 227 that says the school shall not do. I think a stronger bill would say is the school and none of its employees or agents, so that you have individual commands that are responsible for violating, because as it's crafted now, this is on page 3 of 5. And subsection E is just, this is an example that relates to school records. It says school districts are prohibited from using policies or procedures that have the effect of excluding procedures. So that makes it sound like what you're excluding is like a formal school policy that has that effect. It doesn't really speak to the so-called wildcat employee who's off on their own detail. And, if you want a stronger law to deter that, in terms of their professionals own their own career and personnel consequences, to have a state law prohibiting them from going off script and doing that anyways may have a stronger deterrent effect. There are no penalties here, but it has a stronger command, I think, and maybe.
So you're saying school districts, its employees.
Yeah, I think like those are California. There was a much broader California law that included, there are only 2 state laws that address this topic that have been signed. One is it's an amendment for California Education Code 234.7. refers to school officials and employees of a local education agency. So language like that, so you identify individuals as well as entities.
Full sense.
In that same paragraph, and this is because we find this language in other laws dealing with discriminatory practices or impact. In that same paragraph, I would, have you consider just you're not just using policies and procedures to engage in this, but just engaging in conduct that may not be part of a policy, that has, and often the language that we encounter is the purpose or effect. So a failed attempt to scare out kids from going to school may be something you want to sanction, even if it's ultimately unsuccessful. We find that in areas of discrimination law where I do something to try to intimidate you not to come to work, but you show up anyway and kind of tough it out. It's still a violation of me to try even to do that. It's like an attempted crime kind of principle. So purpose or effect is something to consider. On the area of non-public, just to give you an example of what, it's very, I think the senators offered something I haven't had a chance to review. Like the California Education Code doesn't define non-public at all. They have case law on what non-public means. One avenue to explore, especially if you're thinking about the terms of a model policy, will be to have the model policy identify what counts. Because even the example of a football field, which you might say is an open gate, free admission. My kids went to U32, you just walk on, just walk on, sit on the hillside. But there are parts of an athletic field that might indeed have expectations of privacy. It's not uncommon. In football or lacrosse games, they have a medical tent that's set up. So if a player is injured, they go inside. Sometimes the students disrobe and they're being examined. So I think school policies give the whoever's going to draft that will have the ability, I think, if you just say non-public or give some examples of non-public, to have that appropriate level of granularity. And then if school districts are allowed to tailor it to their physical plans, because some schools have like a vocational aspect of their campus and other ones might be just classrooms. Then that policy mechanism gives you that level of granularity. And that would be true with the issues of exigency, which usually is talking about an imminent risk of death or serious bodily injury. That's the language you usually see for imminent risk or those sorts of things. It's a matter of practice because there's no sanction here for a superintendent. It seems to me rather speculative that somehow harm would befall a superintendent if he blocks the door and there's an active shooter, or an armed person runs into the building. But a policy is a great place to put that, and it would be something that we would certainly, if we were asked to provide guidance, we would certainly address that in some detail. So I think that policy mechanism does give you a lot of room to flesh out some of these granular details if you decide not to put them in the statute. And it's easier to change them sometimes than just change the statute. So I think that's the strength of the bill to have that feature. There is, with respect to just, again, these are just minor topics, just things to consider. Again, on page 3, with respect to student records and talking about directory information. And so that directory information is just a non-FERPA covered. You don't need to consent to disclose. There are some protected categories here, but there are other ones that aren't mentioned, like race is not mentioned or color is not mentioned. There may be other federal laws that preclude you from mentioning disability. But I would try to, I would at least examine whether you would have a more fulsome, because this would be the information that a school would be choosing to put in, out to the public. And it's hard in many of those cases, it's hard to find how things would be relevant. And some of the information about national origin, I think there was discussion of that earlier and part of our practice in AG's office, which deals with hate crimes. Knowledge, information or misinformation about someone's national origin may increase their risk of bullying or harassment or even criminal intimidation. There are there are certain parts of the globe which periodically, depending on the U.S.'s international actions, relations, are in the news. And our experience is that when things happen on a national, international stage, people who come from those countries that are in everyday's headlines tend to encounter more conflict in the community. And so unless there's, some need to collect that information, like I say, with respect to federally supported student exchange program where you need to know where the students from. You need to know that they're actually a foreign student to get the funding, for example. So to just broaden that to the other protected categories like race and color. And you can find those protected categories in the Vermont Public Accommodations Act, which also governs schools because they are a public accommodation. That might be a source for those different protected categories to consider. I think you've covered the ground very well about how to treat different types of law enforcement. There's an Illinois law that was it's the second state law that's passed it that has a specific exemption in the statute for school resource officers. That's I guess the bill that was signed in August of last year went into effect this January is HB 3247. That has a specific exclusion you might want to look. That also might be the language for different sorts of language that you're
I
looking.
think what we can do is just have like try this stuff on, and we can look at it. You suggested, so, but yeah, he's been nodding the whole time.
Oh, okay.
So,
Okay. Well,
only a couple of tricks.
yeah. But fair enough. I think I saw, and maybe you've already taken into account at a different meeting that I'd seen a request somewhere to have more than one individual be the designee of the superintendent. So to have that ability. The question is, one question may be, and it may just come up when you're actually trying to administer a model policy, is whether your policy identifies who those peoples are, or another area. And again, maybe this is the off ramp in terms of whatever is handed off to whoever's going to write the guidance. Typically if you have a model policy, you want to have a mechanism where you report violations and it means to report anonymously violations so that there's actual accountability. You have people who are aware of the district but don't know where to go. And that's my experience is that they just start guessing. They might go to AOE, they might go to us, they might go to Human Rights Commission. So that would be something for the school districts. Whoever going to write that would be a decision for them to make. If there are the other thing, so there are two other things that I mentioned before that weren't discussed today, and for consideration. One is I told you there were these two federal laws that place limitations on when you can have voluntary communications with federal authorities. And I mentioned that there's a Second Circuit case that says that the states have the strongest interest in restricting those communications when you have a general privacy policy. This policy seems to follow that direction. But I mentioned that that two other state laws that deal with law enforcement, which have similar restrictions on communications, have language saying that just like a savings clause that says nothing here is intended to violate the lawful requirements of that law. I noted in my preparation for today's appearance before you that the two laws that have been enacted, the California law, the Education Code 234.7, and the Illinois law HB, both of them have the savings clause citing those two statutes. And I think that just reflects that their analysis is similar to ours, that it's something that those two statutes often show up in federal grants where you agree comply with various applicable laws, including Title VI, including Title VII, and Title IX. But we've seen them in different administrations include those two statutes, and so that's language that I would have to let council look at.
Yeah.
The other question is whether if you have a model policy and then you have individual policies that are they're able to tailor to their facilities, then the question becomes what mechanism is there to ensure compliance? And I don't know what that would be or means to do it. With respect to the statewide fair and impartial policing policy, if they're out of compliance by a certain date, or if they don't adopt the policy, there's an automatic mechanism says you automatically adopt the model policy. But if you have another policy that's not in compliance, there's a mechanism for the Criminal Justice Council and the Attorney General's office to work with the agency to bring it into compliance. And if it refuses, then it's just subject to the model policy by default. And if it refuses, there's another law, 20 VSA 2359, that says if you had an agency that just says we're not going to follow it, and it's kind of their own level of disobedience, and they lose access to certain state resources that support law enforcement. So the legislature did this in 2020, kind of created and teeth to the enforcement of that.
We could just try on while it becomes, but let's see what it does.
And the original statute did just that, just had an automatic reversion.
Okay, we got it. 12 minutes with Tucker around. We have to go. So thank you. Yes, so you've got enough for another draft, so we could keep moving. Julio, thanks. Both of you. Thank you. Sure. Switching gears quickly to the library bill. Yes.
Great.
On these all, on these it's one of this.
Yeah, one of that.
Okay.
Okay.
Yeah. And we'll tell you why.
Why is that?
We'll tell you why there's two.
There should be two.
One has 8 pages, one has 9.
All right.
3.1.
Good afternoon, Tucker Anderson, Legislative Council. You should have in front of you two different new strike-all versions of the committee's amendments S232. You will note the differences in the upper left-hand corner, in the bottom right-hand corner. You'll see draft 2.1 versus draft 3.1. In the lower right-hand corner, you'll see the version number is different. The two versions are very simple, with the exception of one section of the proposed amendment, where there are two different proposals for how the after school and summer programming grant funding diverted through the Department of Libraries is structured. Would the committee like me to do the strike all run through now, or given the time we have, would you like me to start by focusing on the differences between the two proposals? So if you can give me some direction on that section.
Okay, what do we do then?
Okay. So if you are with me in version 2.1, the language is in section 3. This amends 16 BSA section 51 to reorient into this. This is the Universal After School and Summer Special Fund. You heard testimony about this yesterday. The eligibility criteria and the application process for public libraries to get grant funding under this program. The committee is considering two different ways to handle allocating funds to the Department of Libraries for purposes of a separately administered grant program for public libraries. So in version 2.1, it maintains the language in the bill as introduced in subdivision A2, stating that a reasonable portion of funding shall be used by the department to support grants for after school and summer programs in libraries. The only change here from the underlying bill is leaving this broad to be after school and summer programs. There used to be a reference to a specific summer program in the bill as introduced, so it's a little broader there.
You switch over to version 3.1, same section of the bill, section 3. On page 3, this establishes default threshold funding from this fund set aside to the department for purposes of this program. And I did consult with the experts in JFO around the specific type of language that should be used here. So hopefully this is correct. 95% of the cannabis sales tax revenue that's deposited in the fund shall be used by the Agency of Education. And then the existing language around the eligibility stays in place for that 95%. Subdivision 2, 5% of that revenue deposited in the fund shall be used by the Department of Libraries to support after school and summer programming in libraries. And then I broke out a new subdivision 3 to apply the current eligibility and use criteria in this section to both programs. The one run by the agency and the one run by the department. This is different from what you've heard about with the application process. This is just the types of grant support that can be given out discretionarily by the agency, the department, and some of the requirements for contracts that are issued under the program.
So just to be clear about this, that but unfortunately, 3.1, we're not saying that when the Department of Libraries gives out grants, it's because that's state money. It's not subject to all the federal requirements that will wrapped up. Okay, it's not to be simple and simple. Yeah,
They can set up their own program. It would still fall under the requirements. You know, there's one mandatory requirement. It's in that subdivision C that any subsequent contract written agreement that's issued pursuant to an award requires that the grantee not discriminate or prohibit its employees, agents, subcontractors, and other providers from discriminating on the basis of race, creed, color, national or marital status, sex, sexual orientation, gender identity, or disability. So you have two Fs. And to be clear, the first, the agency retains authority over the grant program, but a reasonable portion is allocated to the Department of Libraries as part of that grant program. Version 2, you split off 5% of the revenue in this fund for the Department of Libraries, and you could choose a different threshold amount. That's just what was discussed yesterday. Within that scheme, one of the things that I've mentioned to the chair is that you could always set a maximum funding amount as well. So you could restructure this to say that the lesser of 5% from the fund, or dream up whatever number you want, $100,000, $200,000, whatever, would be allocated to the Department of Libraries.
let's see, questions, so for the record.
Yeah, for the record, Catherine Delano, the State Librarian and Commissioner of Department of Libraries. Just a clarifying question about the new language in draft 3.1, the one with the percentages. In section 3, I guess on page 3, in section 2, starting on line 5. Is this envisioned to support programming at any library or at public libraries? So considering that there are school libraries, there are public libraries, the committee might want to consider the addition of words to clarify which types of libraries you mean. So instead of saying support after school and summer programming at libraries, which is general, it could be academic, special libraries, museum libraries. If you're intending public libraries, then you might want to insert that language.
I think we have been talking about public libraries, but which includes private libraries, public.
Yes.
Yeah.
I'm still nervous about the school section, I would say, because we haven't seen, somebody may have said there's a link somewhere, I don't remember getting it. We haven't seen where it's currently going, what percent would make sense to go to libraries. I feel, I can't do this in the dark. Like, I think there were other very worthy places that this money
Well,
goes.
this is why we had this discussion.
Yeah,
You're raising exactly the reason we had this discussion.
but I haven't seen any data.
Yeah, you mean we haven't seen data on where the grants are going at this point?
Yes.
We've got a number of examples.
You know, somebody should have a spreadsheet.
Yeah, didn't get a spreadsheet.
AOE should give us a spreadsheet. Where are they?
What you know is that virtually none is going to libraries. You know that was,
They even said that.
we had that estimate.
Right.
And the reason it's not going to libraries is that they tend to be smaller institutions and it's not worth their time to build.
Right.
So you
Let the
got-
record show, I don't dislike libraries, but I also like lots of other places that do after school.
Exactly, fair enough. That's why we're having this discussion.
Okay.
So,
I wouldn't exclude school libraries.
no, the only thing I'm saying, my only point is
Okay.
that what we know is that it's not happening. That much we know.
Okay.
We don't know where the 100% is going to, which the libraries are getting done.
Right.
We don't know that. At least the percentages, but we do know that's not, the program is not.
I don't want to exclude any type of library. We have, I mean, like King Street Center and Boys and Girls Club get some of this, so maybe, I don't know what a private library looks like, but I imagine there's good reason if they have an after school program.
I think the reason you asked the question is, would it include like school libraries?
Yeah, just so that if you did decide to include language, that the department has instruction on that. Typically, what we did hear testimony on from Agency of Education from Johannes was that no libraries have been successful in submitting applications and receiving the money. And I also have not seen a list, so I just want to
Did
agree.
he say no school libraries that got?
No, my understanding is he was talking about public libraries specifically, and even with public libraries specifically, there may be a public library that's a partner agency to after school, was what I recall him saying, but he'd be the best person to answer that.
But
From the
there's
department-
also Boys and Girls Club can come into your school library because it's really good for kids not to have to leave campus
Right.
and walk somewhere else.
Yeah, so just to clarify, I think as far as what the intention of the bill, it was really trying to call it out for public libraries. I know I went to summer reading at my public school in South Burlington. They opened it in the summer. That's not, if they're doing the statewide summer reading program, the department's not opposed to granting money to them, just would like clarity in the bill.
Here to go.
Yes, I would note that the term libraries was used at the bill was introduced, broadest possible term, because public libraries in Title 22 is specifically defined. And I'm not sure that even under the current statute, it does include libraries. I'm not certain that it includes school libraries because they're not separate organizations.
And they
They're a
already could get.
facility within.
I hate when we hears things apart so much that we just lose track of the general, like where kids are.
So if we would, if make this helpful, we could have Daphne back in touch with the agency and we could get the list of grantees under the existing program. It's only been in place for 2 years. Is that right?
Who's been?
So I think the cannabis money's only been there for 2 years, I think 2 years. So we've had 2 years of history. And so why don't we have him back with the list? So why don't we do that? And you actually had, if you had time, there's more you would show us in this.
Well, yes, I would just walk you through all of the instances that we walked through yesterday and the underlying bill, because it was a request that you get a refresher on the total contents.
Yeah.
Of it.
So don't lose these, everybody. All right, comments.
Thank you all.
We'll try again as early as we can. We take a quick break and be back at 3 o'clock.